Good morning, everyone. Welcome to our webinar on employee retention. I'm pleased to have my colleagues Phoebe and Mel with me to discuss this topic. So why are we talking about employee retention? Tom, if you could pop to the next slide, please. We carried out a survey at the end of last year, and we asked HR people within the UK to identify their top 5 priorities for 2024. And the most common entry within those top 5 priorities by a substantial distance was retention of employees. So it seems to be an important topic, an important priority for HR this year, which is why we wanted to cover it. In terms of why retention of employees is an important priority, Tom, if you could pop to the next slide, please. What our survey found with 81% of businesses said they face challenges in recruiting employees. And obviously, if you're experiencing difficulty with recruitment, then I can see why it's a priority to try and retain your talent, because they are tough to replace. The main reasons cited for that recruitment gap, or the main reason, was difficulty finding people with the right skills or sufficient experience, you'll find there. But an interesting one in 4th place there in that survey was working arrangements, and people preferring to work from home or preferring their own working arrangements, and therefore it being more difficult to recruit and accommodate people. So one of the things that we are going to look at today is that issue around working arrangements. You can pop to the next slide, please, Tom. So employee retention is a top HR priority for businesses, but who are we as employment lawyers to lecture you on employee retention? Because employment lawyers only dismiss people, don't we? We only get involved in that. What do we know about employee retention? And that's a fair question. And there are elements of an employee retention strategy that we won't lecture you on. Organisation culture, benefit packages, developing employees, upskilling and training employees. We're not going to seek to cover those areas because we aren't the experts in those fields. However, there are some themes that do arise out of retention, flexible working being one of them, where there is an important legal framework within which we need to operate. And that's where we feel we can add some value by discussing those topics. So as Tom mentioned, if you do have any questions, please pop them in the Q&A function. If at any point you feel we are straying into who are you to tell me what to do territory, then I'm afraid there isn't a button to click to do that. You will just have to scream into your own computer screen. Pop to the next slide, please, Tom. Before we go on to discuss the law around flexible working and some developments in that area, just to look at a hot topic at the moment, and we've seen a number of high-profile businesses talk about getting staff to return to the office and the impact that is having on retention. And we asked, as part of our survey, around this, and what reasons are you being given for, if you are being given resistance to, or experiencing resistance to return to work in the office, what reasons are being given for that? And this was the result. And you'll see the most popular reasons are about work-life balance, commuting time and commuting cost. I found, just before we move on, I found the interesting thing here is 36% of employers had people say they didn't want to return to the office because they feared separation from pets. Only 21% said it was because they worried about separation from family members. So pets are obviously more important to us than our family members. Mel's now going to look at flexible working reform and the context of this in terms of retaining employees. Thanks.
Thanks, Matt. If we can have the next slide then, please, Tom. So, I think we're all probably aware that flexible working, hybrid working, the ability to sort of choose where we want to be from one day to the next is really high upon a lot of people's agenda. That's both candidates and existing staff. The pandemic has made people reassess their priorities, pets included, seemingly. But, part-time working isn't just having a Monday off to look after your kids anymore, okay? It is a really broad spectrum of variations on one's working pattern, narrowed down really to the hours of work, the location, and the days of work, okay? And it's incredibly broad. It could be job share, it could be part-time working, compressed hours, hybrid working, remote working, so lots of different varieties that help people work in the way that they consider to be best. Many of you will be aware that there's been some changes in this space. But to recap, with effect from the 6th of April this year, the right to request flexible working is now open to all employees. So there is not a minimum period of service required of 26 weeks, which it was historically. So I could start working for you on a Monday full time, and on the Tuesday I could submit a request to work part-time. That's the reality. In addition to the removal of the qualifying service stipulation, the law has changed to permit 2 requests a year in any 12-month period instead of 1. Okay, and employers now have to deal with any request for flexible working under the statutory procedure within a period of 2 months instead of 3. So there is a shorter time frame. In addition to that, the applicant is no longer required to specify or justify the impact of the change requested on the organisation. Okay, so quite a few changes to grapple with. Now, some people have said, well, is this going to result in more employers having to say yes? Not necessarily, is my view. Let's remember that this is still just a right to request flexible working, not to have it, okay? An employer is entitled to reject a request for flexible working for one of 8 specified statutory reasons if they think it's going to impact their organisation detrimentally, okay? You have to consider those very carefully, and there's a procedure attached to flexible working that an employer has to follow. But if somebody submits a flexible working request, it doesn't necessarily mean that the employer has to say yes. Okay. What it does mean, I think, for employers is there probably will be an increase in requests, and obviously that's going to have an administrative impact. Could we look on the next slide, please, Tom? So just having a look then at some of the legal risks and claims that can flow from flexible working requests not being handled correctly. And first of all, I just want to talk a little bit about the actual process and the procedure that an employer has to follow. It's really important that employers follow the ACAS code on flexible working. It's really important that employers consult with their staff, have a meeting with them, and offer them the right to appeal against any outcome of their flexible working request. Because an employee who's made a request under the statutory procedure, a written request, can bring a claim to an employment tribunal on various grounds. One is that their employer failed to deal with the request reasonably, in a reasonable manner, that their employer refused the request without consulting with them, that the employer failed to notify them of the decision within the specified 2-month period, and that the employer rejected the request for a reason other than one of the 8 legal reasons permitted. They can also argue that the employer's decision to reject the request was based on incorrect facts, so it was just wrong. And they can also say that the employer treated the request as withdrawn when it wasn't. Okay. Claim can't be brought on the first 4 of those grounds until the employer has notified the employee of the decision on the request or the decision period has come to an end. We'll have to see how the remedies and claims in this space play out through the case law, essentially. But it's open to an employment tribunal to order an employer to reconsider the decision or to award compensation of up to 8 weeks' pay for somebody who brings a claim in this respect. So it's not a tiny amount we're looking at. In addition to the procedural claims, I also want to mention indirect discrimination claims, okay? Indirect discrimination is where there has been what we call a PCP, provision, practice or criteria, applied to everybody neutrally, so neutral PCP, but it has a disparate effect on a group with a protected characteristic. And that PCP is not a proportionate means of achieving a legitimate aim. So some common examples for you, which are relevant to flexible working and the sorts of issues we're talking about, are a requirement on everyone to work full time, okay? That's a PCP. A requirement on everyone to work full time appears neutral on the face of it, but it has an impact on women in particular, indirectly discriminates against women who statistically have larger childcare responsibilities, okay? Another example is a requirement on everybody to attend the office. The rule applies to everybody, but that's going to potentially impact more disabled employees who may, for example, have mobility issues and struggle to physically get into the office. Okay, another example might be requirement on everybody to work hours, specific hours at certain times of the week, which might impact people with a protected characteristic of religion. Okay. So when we're looking at flexible working requests, and if we're declining a flexible working request, we need to be prepared to defend any rule, provision, criteria, or practice, and any deviation from it. See, the pandemic has shown what people are capable in terms of home working. So it might be quite difficult to justify having an outright rule that everybody has to come in all the time, for example. Want to mention also a new point on the indirect discrimination, which gets a little bit technical and complicated, but I'll keep it as basic and straightforward as possible, giving you an example. So this is in respect of change to the Equality Act, which was made on the 1st of January this year, to bring it into line with some European case law, which otherwise wouldn't apply because of Brexit. And it came about because of a case involving a Romanian lady. This lady lived in an area of town that had significant Roma population. She wasn't of Roma origin, but the authorities in the area where this lady lived decided to fix the electricity meters very high up because of concerns that the authorities had about Roma families tampering with the meters. As a result, this lady couldn't see her meter, couldn't check her electricity bills were being done correctly, and she raised a claim of indirect discrimination. Now, up until this point, our understanding was that she couldn't bring a claim of indirect discrimination because she wasn't part of the disadvantaged discriminated group. We thought you had to be part of the disadvantaged group to bring the claim. And the European Court of Justice in this case said that wasn't correct. As a result of that, we now have Section 19A in the Equality Act, which clarifies that a claim can be brought where there's a PCP, provision, practice, or criteria, which applies to people who have a protected characteristic and to those who don't have that protected characteristic who share the disadvantage. Putting that example directly into a flexible working scenario, a man with primary childcaring responsibilities could be placed at a disadvantage by his employer's demand that he works full time. He could bring an indirect sex discrimination claim on the basis that that requirement to work full time puts more women at a disadvantage and that he shares that disadvantage. So the scope is broadening. Another discrimination area to be aware of when we're looking at flexible working is that which applies to disabled employees who might be making a flexible working request as a reasonable adjustment. Now, if you have an employee who's disabled, you're under a legal duty to make reasonable adjustments to alleviate any disadvantage that they're suffering. And examples of reasonable adjustments given in the Equality and Human Rights Commission Code include things like altering hours of work, allowing the employee to be absent during certain working hours for rehabilitation, etc., and disability leave. So that's something to bear in mind. The stakes can be very high with discrimination claims because compensation for injury to feelings and discrimination claims is uncapped. There's no limit on that. And the final thing I just want to mention about sort of legal claims that might flow in flexible working situations is constructive unfair dismissal. So somebody is constructively unfairly dismissed if their employer breaches their contract, and it's so serious that it destroys the contractual relationship. If an employer deals with a flexible working request very badly, or if it's discriminatory, an employee might resign and say that trust and confidence has been breached and they can't work there anymore, and treating themselves as constructively dismissed. So that often goes hand in hand with discrimination claims that flow in a flexible working context. We have the next slide, please, Tom. So just a few minutes then to consider some practical issues with the granting of flexible working requests. Is it permanent change? Is it a temporary change? Well, the default position is if somebody's making a flexible working request, unless they say otherwise, it's intended to be permanent. So if that's not the intention, or if an employer is just granting it on a trial basis, you need to be very clear about that. One of the issues we've seen that emerged from the pandemic, lots of sort of hybrid working arrangements ended up happening quite fluidly. So a lot of the formalities that go with home working were just missed, okay? And it can be quite difficult now to sort of pull that back. So if you're putting in arrangements for flexible working, home working, remote working at the moment, it's really important to have clear terms and conditions that surround that, and some practical issues to consider. Risk assessments. Employers obviously have a duty to provide a safe working environment. So the days of putting the laptop on the ironing board in lockdown are well behind us, thankfully. And risk assessment covers both physical and mental health. ACAS have a guide on well-being when working from home, which is really good, accessible read. You might want to have a look at that. And as an aside, maybe a topic for another day, the ACAS code also covers the risk of domestic abuse. So some people don't live in stable environments, and if they're working at home, they might be exposed to some extra risk in that respect, is something to bear in mind. Then there's the matter of insurance for equipment. Obviously, if your staff are using company employer equipment, who's going to insure it? That's really important, having arrangements in respect of that. And of course, confidentiality and making sure that those people who are working from home or remotely in other locations are complying with our rules on confidential working, confidential information. That could include rules around locking laptops, not using paper, making sure that phone calls, confidential phone calls, are held confidentiality. That's really important with people who are in shared housing. The right to enter the premises. You know, an employer might want to reserve that right, particularly if the employee is using company equipment that might need to be taken back if there's a dispute, for example. And reserving the right to require people to return back to the office. You might not want to make a permanent promise of home working, but if that's the case, that needs to be made clear, and you need to exercise any request for people to return reasonably. Okay. And then just to mention part-time and compressed hours. So for part-timers, the issue we commonly come across is that of what happens with bank holidays, because they're not distributed evenly across the days of the week. Various issues arise. One is ensuring compliance with the working time regulations, i.e. that the individual is receiving 5.6 weeks holiday, which can include bank holidays. And also avoiding a claim for less favourable treatment on the grounds of being a part-time worker, if somebody's ending up with less holiday than they should. In general fairness, holidays can be a very emotional issue, and some employers seek to address the balance by granting extra days to people who don't work on a Monday to ensure fairness. With compressed hours, this is tricky. Compressed hours are becoming more common request. That's possibly working 5 days worth of hours, but compressed into a 4-day working week. Now, the working time regulations talk about weeks holiday. Most employers' holiday entitlement is often based on days, but compressed hours don't really fit neatly into that. Somebody working 5 days in 4, let's say they have a holiday entitlement of 30 days. If you give 30 days to the compressed hours worker, they can take 7.5 weeks holiday. But the 5-day-a-week worker only ends up with 6 weeks holiday. So the compressed hours worker is getting more holiday. It doesn't seem fair. Do you therefore express holiday in hours rather than days? And how to deal with bank holidays for compressed workers who don't work on a Monday. Lots of tricky issues can arise. And with that, I'll move on. Next slide, please, Tom. I'm passing you back to Matt, I think.
Just briefly, one of the other findings from our survey, we asked questions about remote and hybrid working and the impact on employee well-being. And it was interesting to note that there was notwithstanding a desire from some companies to get people to return to the office, that the overwhelming feeling was that remote and hybrid working styles were impacting on employee well-being in a positive way, which is, again, when we're talking about employee retention and the importance of employee well-being, we thought we would share that with you. What we're now going to look at is some of the other recent elements of employment law reform, and Phoebe's going to look at this again in the context of what's the minimum the law requires us to do. Are there things we could be enhancing in terms of employee retention, but certainly ensuring that we comply with that minimum requirement. So if you want to hop onto the next slide, please, Tom. I think we've got Phoebe.
Yes, so following the enactment of the Carers Leave Act,
Has Phoebe frozen?
I think so, yes.
Okay. We'll give Phoebe a couple of seconds to see if she can come back on. If not, then I'll talk you through carers leave until Phoebe does come back on. No, she's not on. So I'll talk you through carers leave. Tom, if you could perhaps try and get hold of Phoebe and just see whether we can remedy that issue. So this was introduced at the same time as all of the other recent reforms, 6th of April this year. There is no qualifying service required for carers leave. Phoebe, are you back on?
I think so, yes.
Yeah, excellent. We can hear you now.
Sorry about that.
Sorry,
Matt, did you get onto long-term care need definitions?
No, I didn't really get into any of the detail of it. So.
Oh, sorry. So I'll pick up on long-term care need and how that's defined. So that's defined as an illness or injury that requires or is likely to require care for more than 3 months. A disability, and that's the same definition that's under the Equality Act, or care for a reason connected with old age. And so the 1 week's leave can be taken in either a block of 1 week, or it can be taken in individual blocks of days or half days. And so around this, employers should consider introducing a carers leave policy. Some employers are choosing to enhance this right and make it paid leave. But as it is unpaid leave, there are no evidential requirements, as the government is assuming that people won't try and take advantage where there is no right to payment. However, if employers do wish to offer paid leave, then they may need to consider whether they require a declaration or anything to dissuade fraud. Further guidance for employers can be found on the gov.uk website or the new Carers Leave ACAS guide. Next slide, please. So next we're taking a look at paternity leave, and the Paternity Leave Amendment Regulations 2024 amended the existing legislation on paternity rights, including to allow paternity leave to be taken as 2 blocks of 1 week rather than only 1 block of either 1 or 2 weeks. And paternity leave can now be taken at any point in the first year after the birth or adoption of their child, rather than only within the first 8 weeks. The amendments also, in most cases, shorten the notice period required for paternity leave to 28 days, and this will enable employees to decide when to take their leave at shorter notice to accommodate the changing needs of their families. The new regulations do not change the notice period required in domestic adoption cases, which remains within 7 days of the adopter having received notice of being matched with a child, since this process is inherently less predictable. The amendments also allow employees to vary the dates for paternity leave on 28 days notice, which enables them to change planned dates at a later stage. So these reforms may not have an impact on employee retention, but wider considerations as to whether to enhance entitlements, for example, by paying full pay rather than just statutory paternity pay, that may have an impact on employee retention. The same goes for enhancing all types of family leave and pay. According to Total Jobs, research shows that 22% of job seekers search for parental leave policies while considering a new job. They will therefore be comparing your policies with those of your competitors. Next slide, please. So the Neonatal Care Leave and Pay Act 2023 was established to provide parents with up to 12 weeks of paid leave if their baby requires neonatal care, on top of existing maternity and paternity entitlements. The Act is set to come into effect in April 2025, allowing employed parents a day one right to leave from work if their baby receives neonatal care for more than 7 continuous days before reaching 28 days old. The Act defines the eligibility criteria and the extent of leave and pay for parents in such circumstances, and it's designed to lessen the financial and emotional stress on families during a challenging time. The Act received royal assent on the 24th of May 2023 and is likely to come into force around April next year to allow time needed to update payroll systems. Some companies are offering support already, and given that this is set to become a statutory right, providing support to employees now could send a positive message and contribute to improved employee retention. And I think I'm handing back to Matt now.
Thanks very much, Phoebe. So for the final section, what we wanted to discuss was concepts of general fairness in the workplace in terms of retaining staff and being perceived to be a fair employer. And the first question I pose on this slide is about, is avoiding unfair dismissal enough in the context of your business? So for years, cold-hearted lawyers like me have given advice like, well, provided there's no discrimination, if the employee's got less than 2 years service, you don't need a fair reason to dismiss, you don't need to follow a fair process, you can terminate. Or, well, if it isn't a formal grievance, you don't need to investigate it. Or if you dismiss this employee and they bring a claim for unfair dismissal, compensation is based on lost earnings, they're in a role where they're likely to find employment in the very near future, your exposure might be relatively low in financial terms. Those are the sort of the cold letter of the law piece of advice. But what we find now is with a struggle for talent and a desire to retain good employees, employers are increasingly considering their values and their internal and external reputation in relation to these issues. Employees can much more easily now, certainly dismissed employees, post a review of their employer that impacts on reputation. All tribunal judgments now are publicly accessible online. And so there is an important debate to be had, I think, about the way in which we approach disciplinary and dismissal issues, particularly for employees with less than 2 years service. The caveat to that discussion is that it may be a discussion we don't need to have in a year or so's time. If we get a new government, and if that new government is a Labour government, they had said that within 100 days of being in power, they would introduce day one rights to claim unfair dismissal and would remove the 2-year qualifying service requirement. Now, I'm very conscious there are a number of ifs there, but that may be where we are in terms of the legal framework this time next year. For the moment, I think there is a bit of a challenge for employers to say, when we're dealing with particularly short servers and we want to retain the entirety of our workforce and look like a good employer, how we treat our short servers is part of that, will play into that perception. Do you want to pop to the next slide, please, Tom? Changing terms and conditions of employment. Again, we've seen a fair amount of publicity about this, and there is now, or there will be very shortly, there's now a draft code of practice on this to take statutory effect, we think, at some point in the summer, colloquially referred to as fire and rehire. In the old days, we used to call this termination and re-engagement. You may remember a couple of years ago, there was a lot of publicity around an exercise carried out by P&O in relation to 800 members of staff, where they terminated their employment offered them re-engagement on new and different terms. That got a lot of publicity. The phrase fire and rehire became very popular, and that appears to be the way people refer to this. Termination and re-engagement is probably the correct way of referring to it, and in the less politically charged way of referring to it. But what the Code of Practice does, because the government introduced this specifically in response to all the publicity around P&O, what the Code of Practice does is, for the first time, it says to employers, if you're in the position of wanting to change terms and conditions of employees, and if one way in which you might have to do that, if the employees don't agree to your proposed changes, is to terminate their existing contracts and offer to re-engage on new contracts, then you should follow this statutory Code of Practice. And if you don't follow the statutory Code of Practice, it doesn't lead to a standalone claim from the employee. So the employee can't say, I bring a claim for a failure to follow the Code of Practice. But if they have a claim arising from that exercise, so for example, a claim of unfair dismissal, compensation can be increased by up to 25%. Equally, as with failure to follow grievance processes, for example, compensation can be reduced by up to 25% if the employee fails to comply with the Code of Practice unreasonably. But there's not a lot for the employee to do under the Code of Practice. So really, this is a code aimed at employers and telling employers what to do if you are embarking on such a process. And it is a not uncommon process. Businesses commonly find that, and they will increasingly find, with the change in work environment, work delivery, customer demands, hours of work, etc., they will want to make changes to terms and conditions of employment. And if they can't agree to those changes, then rather than unilaterally impose them, which would be a breach of contract, might lead to a constructive dismissal claim, the recommended way of doing it is to say to employees, well, look, you won't agree to these, or 5% of you won't agree to these. The other 95% of the workforce have agreed to them. So the only way we can make this change is terminate your existing contract. We're perfectly happy to offer you employment on new terms. Here's the new contract. If you sign it, you'll remain employed by us. If you don't, you'll be dismissed. And we will back ourselves to defend an unfair dismissal claim because we think we've been through a fair process of consultation and we think our reasons for the changes are fair. But it would be a dismissal. So in terms of the content of the Code of Practice, what it talks about is providing information early, so not leaving the consultation to a late stage where it looks as though it's a done deal. It talks about the consultation being meaningful and the consultation being as long as reasonably possible and carried out in good faith. So again, the employer will listen to what employees have to say. That employers should be clear at an early stage that if agreement isn't reached, this might lead to a termination and re-engagement scenario. And there is also an obligation there for employers to re-examine their proposals in response to consultation. So if employees come up with ideas or different proposals, different ways of saving money, different ways of operating the shift pattern, etc., employers are obliged to re-examine their proposals. As with lots of employment legislation in this area, and lots of the collective consultation legislation, employers aren't bound to do what employees demand, but they are bound to give it reasonable consideration. The only other thing to flag from a legal perspective in relation to termination and re-engagement exercises is, of course, if they involve 20 or more employees of one establishment, there are additional obligations in terms of formal collective consultation. It remains to be seen how much of an impact this Code of Practice has on those areas, but with it being introduced, if you are thinking of making changes to terms and conditions, then that's an important thing for which you need to be aware. Next slide, please. Grievances. So we talked about termination of employment. What about grievances in the context of employee retention? And the question that a number of us have posed for a number of years is, do they really resolve the issues? how many grievances are upheld? How many actually resolve matters and improve workplace relationships? Are grievance processes too technical, too adversarial? Do they look like a mini tribunal case? I am complaining of this, you are making a judgment on my complaint. There is a school of thought that says they don't particularly help to resolve issues. Nevertheless, we have an obligation to investigate grievances, and of course we have codes of practice that say this is how you should do it. We no longer have the statutory procedures that we have to follow, but we do have an obligation to follow as a minimum the ACAS code of practice. Otherwise, if there's a successful claim, compensation can be increased by up to 25%. So there are some employers looking for alternative means of resolving grievances, such as mediation. Lots of grievance policies say things like try and resolve things informally before it gets to the formal stage. Our experience is perhaps the significant efforts aren't made at that informal stage. Things do escalate very quickly to the formal level. And that impacts on employee retention in a number of ways, not only from the individual making the complaint, raising the grievance, but we commonly find managers or colleagues against whom grievances have been raised feel that they've been treated unfairly or that they've not been supported through the process. And that prejudices their views about the employer, their willingness to stay there long term. So as an HR strategy, if employee retention is a priority for 2024, as well as things like benefit packages and all of that flows around it and employee culture, I think there is something to be said for taking a step back from grievance policies and saying, look, can we find an effective way within the law to try and resolve these issues without them getting formal and without employers and lawyers being involved? We're involved in far too many grievance processes. We shouldn't be involved. We shouldn't need to be getting lawyers investigating matters or giving advice. We should. I appreciate there are situations where that needs to happen, but for a lot of issues, it does strike me that they could perhaps be resolved in a more meaningful, more informal, and more effective manner. Next slide, please. Pay structures. So if you can remember the slide we went to, one of the difficulties in recruiting was salary expectations from people. In terms of retention, I wanted to talk a bit about pay structures, how this looks now, what our obligations are now, what our obligations may be in the future. So just to remind you, we have at the moment mandatory gender pay gap reporting for employers with more than 250 employees. The government announced, following a consultation, they announced last year that they wouldn't be, the current government will not be mandating ethnicity pay gap reporting. And there is at the moment no obligation to report on disability pay gap. The Labour government had indicated, or the Labour Party, sorry, had indicated that if they were to get into government, that they would introduce ethnicity pay gap reporting and disability pay gap reporting, because there is evidence that there is a pay gap in those areas. And there is also some studies that show, although we don't have a lot of evidence on it, but certainly a perception of a sexual orientation pay gap as well. So there are these issues, and again, in terms of employee retention, of people either visibly seeing pay gaps or not having the evidence, so thinking there is a pay gap there, but not having the evidence. And there may well be a drive, either on a voluntary or a statutory basis, for companies to need to formally report on their pay structures. in terms of addressing the pay gap, I've seen some discussion recently about what they call the ask gap. And what they mean is that the reason there might be a pay gap in relation to, particularly it's talked about in gender and ethnicity, is what pay people ask for. And I think in the US, there's been a bit of an agenda around what they call a salary history ban. So one of the reasons, the perception for the pay gap is, one of the reasons why it's difficult to stop a pay gap is because if you ask candidates for their salary in their current job, and then you base their offer on their salary in their current job, then if in their current job they are suffering from an unfair pay gap, that is just replicated and it carries on being replicated. So the suggestion being that we perhaps shouldn't be asking people what their current salary is. We should be paying what we think is appropriate for the current job and not negotiating or opening a negotiation on the basis of what the current salary is. So those are some sort of thoughts around what legislation might be introduced in relation to pay structures in the near future. As I say, we're not the experts in terms of pay strategy, but what we can say is those visible pay gaps we think do impact on certainly recruitment, but retention as well. Current employees are looking at gender pay gap reports for their own employers when they're published and raising an eyebrow when they see those pay gap reports not closing and thinking, should I be moving to an employer who does have a closing gender pay gap, for example? So that was what we wanted to discuss in terms of the formal basis. In terms of questions, just checking some questions. Mel, I think we've got a couple on flexible working. What if someone makes their 2 flexible working requests every year and they are always unrealistic and they are always rejected? Does there come a point at which we can say enough's enough? You can't ask the same question again and again.
Well, I think that, I'm sure, will be very frustrating, you know, but provided, as far as I'm aware, that somebody's complying with their, you know, sort of request under the statutory framework, you know, they're not strictly doing anything wrong. I can see that it would be disruptive if the same reasons are being rolled out for refusal. I think the focus there would be seeing whether you could come to an agreement with that person. It might be that their flexible working request in its current and repeat form is not one that can be agreed, but kind of variation of it, you know, and that's really important, I think, when dealing with any flexible working request, is having an open mind. You know, somebody might be asking for one specific working pattern that you might not be able to accommodate. That doesn't mean you can't have a conversation about a variation on it. Naturally, that can result in something being agreed that suits both parties. It might not look like what the request was in its original form, but actually, if you're able to say to the employee, well, we can't do that, but we could do it this way, are you willing? You know, that can sort of solve everybody's problems, as it were. So, you know, certainly that might be something to focus on with a repeat requester who's not getting exactly what they want. You know, can we look at something that's going to get them a little bit more to what they want, I think, is my view.
Okay. And then another one on flexible working. What if everyone in the team asks for flexible working? We can grant it for some, but we couldn't grant it for the whole team. So I presume they're asking around something like, we've got 5 people in the office. They all ask to work from home all the time, but we will always need someone in the office. How do we choose who we give the right to and who we don't?
Yeah, it can be tricky, and I think that's a real concern for lots of employers. You know, we get lots of queries about sort of employers receiving flexible working requests, and they don't want to set a precedent, and they don't want everybody to do it, but they don't want to be unfair. And really, it comes down to having to deal with it in order. It's quite rare to have 2 or more employees submit the same request on exactly the same day, quite rare. But you do have to deal with them in order, and really it's sort of, you know, first come, first serve. It might be that you can have 4 people working at home, but not everyone. Now, the last person requesting that is obviously going to say, well, everybody else is doing it. The reason we can't accommodate it is because everybody else is doing it. So, you know, you're not necessarily going to be unfair in refusing that request. You've got to look at the circumstances of the department, you know, whether the customers can be serviced, etc., and just really deal with requests in turn, you know, is all you can do.
Thank you, Mel. And then one I think that's probably for me, because it's something I touched on, was how will day one employment rights under a Labour government operate? Surely we should be able to do something to terminate someone who doesn't turn up for their first week of work with no reason. I mean, the answer to that is I don't know. I've not seen a lot of flesh on the bones of the of that promise to introduce day one rights in relation to unfair dismissal. My suspicion is it might go one of 2 ways. One, there might be some exceptions to it. It might be one of those promises made where there are some exceptions. The other is there might be some impact on compensation. So people who have only a week's service, there might be impacts on compensation. It might be a complete right, and they might simply say, no, you need to follow a fair process in relation to everyone, even if they just don't turn up on their first day. I don't know. I suspect there will be some exceptions and some mitigation there, if indeed we do have a Labour government, and if indeed they do implement that in the way that they've said, in a very broad way. So I think those were all I'm just checking, those were all the questions we had. If there aren't any other questions, then thank you very much for your time. I hope you all have a good rest of the day. Thank you.